With that, we turn to the first case on today's docket. The first case is case number 126181 from Shawnee County, State of Kansas versus Allan Rendale Taylor. Would the parties come forward and then state their appearances?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Allan Turner.
Good morning, Mayor. Please the court. This will be cleared by Deputy District Attorney W. Woodcock.
Thank you. Mr. Hodgkinson, would you like any time for rebuttal?
3 minutes, please.
3 minutes are granted. You may begin.
Good morning, Your Honor, and happy Constitution Day. As I begin this argument, I wanted to make a note. I think that neither my colleague or I cited a case that changed the landscape about the first issue a little bit in this case, State v. Reynolds, that came out from our Supreme Court this summer. I'm assuming that the court is aware of that, notwithstanding that we didn't do that. Is that a fair assumption? All right. That being the case, I just wanted to comment on that. Then it doesn't change the underlying analysis. It just sort of changes the remedy analysis in this case. And so when I filed my brief last September and when my colleague filed her brief afterwards, we didn't know we needed to be arguing this as an instructional issue. So I guess my request is that if the court determines that that's the critical part of this case, that we be allowed to brief that issue, since we didn't know that this case was coming down. So obviously, if the court would reverse for now that it's an instruction issue, if the court would reverse for other trial errors, then I don't, or if the court doesn't agree with the underlying bugs analysis, then whether it's clear error is mode too. So, but if the court determines that, no, that's the critical thing that we didn't have, please don't hold it against my client that we didn't brief it at a time when we didn't know we needed to brief it.
Certainly. Thank you.
Thank you. With that, I'm going to move and plan to start my talk about issue 2, which has to do with the failure to give an eyewitness identification instruction in this case. I think my colleague and I agree that an eyewitness identification instruction is legally appropriate. There's pattern instruction for it. I think my colleague and I agree that identity was a critical contested point in this trial. In fact, it was the critical point. There was no real debate that an attack happened in this case.
Can you clarify for me, was it requested and denied?
It was not requested. So to the extent that you would find that it's also factually appropriate, we would be having to prove clear error. So my colleague, I think, agrees that it's factually appropriate if identity was a critical element in this case, and I think the state agrees that. Also, whether there were significant issues with identification in this case. And I guess maybe that's a point of dispute between my colleague and I, that I certainly think that the identification in this case that has to do with a person seen under extreme circumstances in a darkened room, that there are significant issues with identity in this case that could lead to misidentification, and therefore eyewitness identification.
Counsel, in the state's brief, the argument's made that there may have been questions about identification, but there wasn't any question about the reliability of the witness's testimony. Could you speak to that?
No, I think there were, I mean, the circumstances are what make it there be a question for factual appropriateness, especially with regard to the reliability of the witness. So, I mean, the fact that it was in a dark room, I mean, when you look at that, like, here's what we would have told the jury had we given this instruction. How many of these factors would apply? Almost all of them. Almost all of them would have been relevant information for a jury trying to decide whether the identification in this case was reliable, right? It's not our job, it's not your job to decide whether this identification was reliable. It was the jury's job to decide whether this identification was reliable. And the question is, did they have the tools to do that?
Argued by either side during closing argument, say?
You know, I don't remember, and I'll come back to that point a little bit when I talk about clear error more. I don't remember the details of that, my colleague might, but I wouldn't, even if they were argued to some extent, that's different than being able to argue it based on a judge's instruction. And so maybe I'll just move to clear if you find that the instruction in this case was also factually appropriate and that's in a light most favorable to my client, then under Reynolds, not Reynolds, but under the statute, we have to prove clear error. I mean, that's an interesting conundrum some days, these days it feels like to me. But assuming there is such a thing as clear error still, my colleague is arguing that, well, they had an attorney and they gave a reasonable doubt instruction. And so, how would it have been any different? I would argue, Your Honor, that this court in Simpson faced facts very much like this and found there was clear error. There was a real possibility that a jury would have come back with a different determination had the jury been given the tools to fully evaluate the reliability of that. And the other thing I would point out is my colleague cited State v. Marshall, I think, from the Kansas Supreme Court as part of the response there. And in Marshall, though, if you look at it carefully, I'm not sure it really supports her point. In fact, it may run counter to her point, because in Marshall, they gave an eyewitness ID instruction. And there was just one part of that instruction that dealt with certainty that the court had said that's actually not relevant to a reliability decision anymore. And so that was the discussion there. To your point, Judge Warner, that, I mean, in that case, the attorney did go through, because there was an eyewitness identification instruction given, and the attorney did go through that instruction. The rest of that instruction was able to explain to the jury using the tools given by the judge why that attorney didn't think it. That didn't happen in this case because there was no eyewitness identification instruction given at all. The jury was not given any of the tools that are provided by the instruction in this case. So it certainly is our position, and I think the record demonstrates that the instruction is factually appropriate in this case. It was obviously legally appropriate, and that like Simpson, in these circumstances where you have a witness seeing somebody in a dark room under extreme circumstances, that in a very short amount of time, that the opportunity for misidentification was great, and it's exactly when this kind of instruction is needed. The second issue that I will talk about today, or that I plan to talk about today, has to do with the hearsay issue. In this case, I'm not sure we disagree that there was an error here. In this case, on rebuttal, the state put on some evidence after my client got up and testified about how there was another person. And that's certainly my client's sort of theory of the case here, that it wasn't my client that did this attack, that it was another person. And the state put on this evidence over a hearsay objection about on the radio, police radio, was there any other information about another person? It was objected to and overruled, and there was an answer. I'm not sure that my colleague disagreed. I think my colleague agrees that that might have been error. Certainly the judge's reasoning was error. But the question, I think, is, was it harmless error? And my colleague's response is, well, there was other evidence that there was nobody there. There were other videos and things like that that showed there was nobody there. And that's true, but that's different kind and quality of evidence than saying no police officer on this radio that said that there was anybody else there. And I would point out, I mean, they brought that out in rebuttal, specifically in response to my client's claim and evidence that there was another person there. They specifically brought it out for that point. And so the state certainly thought it mattered.
But how does that differ then from the testimony of the police officer who says, I didn't see anyone else? I mean, how does that really differ? How do we get past harmlessness?
Yeah, it's different from saying one police officer didn't see that, or even two police officers didn't see that, to saying no police officer saw that. The quality and quantity of that evidence is different, as evidenced by the fact that the state thought it was important enough to bring it up in rebuttal to my client's testimony. They thought it was important. They thought it mattered, until now, maybe when they think it was erroneously admitted.
Mr. Hodgkins, I hate to mix issues, but it seems to me that after your client testified, as he did this, there was somebody else there. Doesn't that call into question the identification of him as the perpetrator even more? The jury has to consider all of that. Did she identify him? And isn't that another reason why the instruction should have been given?
The eyewitness identification instruction.
Yeah.
Yes, of course, Your Honor. I mean, it's additional. It's not just a case where a person testified and there's no contrary testimony. In this case, this was a hotly contested issue, as demonstrated by my client's testimony.
Okay. Now, you can go back to your hearsay.
I think I'm done.
Counsel, I do have a question in it, and it dovetails a little bit from what Judge Hill was asking. And that is, like, I know after Waldschmidt that we do not consider instructional errors in a cumulative error analysis. But what do we do with all of these different harmlessness standards? How do we consider those if we were to say, look at a cumulative error question?
How much time do I have left here?
Supplemental briefing.
Supplemental briefing. Certainly, the Kansas Supreme Court has said that you should not consider unpreserved, that's not the right characterization, unobjected to or unrequested instructions in a cumulative error analysis. So, I mean, how do you consider those? And I guess you don't. I mean, that's what they said. And I recognize you're bound by what the Kansas Supreme Court said. I don't understand that, but I don't understand a lot of
But even putting the
things.
instructional questions aside, we're dealing with a hearsay, which has just our regular harmlessness question. We
Oh.
have questions about prosecutorial error, which are subject to
Sure.
a different analysis.
Okay. So yeah, I mean, you could find, for example, that, yeah, it was error, the hearsay error, and if there was prosecutorial error, then how do those combine? Well, prosecutorial error is reviewed for reversal based on a constitutional standard under Chapman. And I think it's still good law that when you do a cumulative error analysis, if any of them are that constitutional error test, then you do the cumulative error test from a beyond a reasonable doubt standpoint. So that would be how that, to the extent that there are other errors that can be considered in cumulative error, that's how you would analyze it.
Thank you.
Yeah. Your Honor, that's all I have, unless you.
All right. You have
Thank you.
3 minutes reserved for rebuttal. Counsel, welcome.
Good morning. May it please the court. I'll start with issue 2 as well. As this court has heard, the defendant did not request the eyewitness identification instruction here, so we're in clear error review.
Why didn't the state?
I guess I would argue that the state did not because there wasn't any serious question about the reliability of the witness in the state's view. And in order for there to trigger, I guess, this pick instruction, there needs to be some sort of serious question about the reliability of the witness.
Really? I used to give it routinely whenever there was an eyewitness because I thought it was up to the jury to decide whether it was requested or not, because it's the court's responsibility to instruct the jury on the law. And I used to give it routinely with every eyewitness because I thought that the jury needed to understand the legal framework that they had to use to evaluate somebody's testimony. But clearly it wasn't asked for here.
Correct. And it may be best practice to give it. I won't disagree with that, especially in an eyewitness
I
case.
appreciate that.
But it wasn't requested here. And to the state's argument, there was no serious question about her reliability.
Well, until he gets up and testifies, there was somebody else there. Now, that clearly brings in a question to the jury. They're going to have to evaluate, first of all, they'll have to evaluate his testimony and weigh that against her testimony. And there you are. When they start balancing like that, that's the brilliance of having that instruction.
And I agree, it's a helpful instruction. They were given an instruction, I think it was during instruction 7, on it's the jury's duty to determine the weight and credibility to be given to each witness. Mixing it kind of with my prosecutorial error, what I wrote for that part of the brief, the prosecutor stated, I want to say 4 or 5 times, that was the jury's duty. You have to decide what weight and credibility you give to the victim and what weight and credibility you give to him. He's produced this testimony about Deuce. Do you believe that it was Deuce? Do you believe that it was him? So I think the jury understood that they could use their common knowledge and experience to weigh the credibility of each witness. And these factors were, even though there wasn't an instruction given, these factors were argued. So defense counsel in cross-examination, if I can get to it, he challenged the victim's credibility on what she saw. He challenged the fact that she saw the man with no shirt on but couldn't remember if he had any tattoos. They talked about how dark the room was. She didn't give an estimate of the man's age at the time. that when she saw him in custody, that was the first time that she had seen him in a fully lit room, and noted that the man had a mask over his face, which I don't know if that was ever cleared up. I didn't go back to look at that. So, she saw him in a dark room with a mask on her face. All of that was brought out in closing argument. So her credibility was contested and challenged. And in closing argument, defendant's attorney also challenged her credibility. She noted that she didn't report what he said to her initially, but only did so later to the detective, and noted that she didn't hear the chiming of the gate before the exit door alarm, but another nurse did. So I think her credibility was challenged, and that goes to the other sort of procedural safeguards.
But what's the point of the eyewitness pattern instruction if it's always absolved by giving just a general credibility instruction?
I don't know that it's always absolved by giving a general credibility instruction, but I guess that goes to the point that there were other procedural safeguards here that happened. So if this instruction wasn't given, there were still some safeguards to look at when determining whether this was clear error. Additionally,
Does it matter that those safeguards were pointed out by the parties, not instructed as a toolkit from the court?
I don't think so. Again, we could be talking about best practice here, but I don't think it amounts to clear error when those things were argued. And the jury knew that they had to weigh those things. And they also knew that there was of course, a burden of proof instruction here. So I would argue that the same sort of factors that are in that PIC instruction were argued by the parties, and they informed the jury that they needed to take those things into consideration. As to the third issue, in rereading my brief, I don't know that I argued that it wasn't hearsay. The state just kind of glossed over and said, even if it is, it's harmless, which I agree with. We think it is harmless ultimately, even if this court does find its error. But in looking at the actual testimony and the question that was asked, I don't know that it is actually hearsay to ask, did you hear any radio traffic from other officers who were in the vicinity of anyone that was on the property that was suspicious? So the question was, did you hear anything? And maybe the answer would have invoked a hearsay exception if you would have said yes, and then asked, what did you hear? That could have been hearsay, I guess, because we're getting into an actual statement. But the question here is not, what statements did you hear? It was, did you hear any radio traffic stop?
But wasn't that within the context of, did you see anyone? No. Did you hear anything? So the implication was, did you hear anything on the radio that would have also corroborated this?
Yes. And to my colleague's point, yeah, we did bring it in on rebuttal to kind of combat what he said about this deuce who was there. So, but I don't know that there's a statement there. It's really the absence of a statement. So I don't know.
By implication.
Right. I mean, yeah, it's interesting that, and if he would have said yes, the defense would have wanted that in, of course, but the answer was no. So, I mean, yes, that is the implication that no statement was heard, or no suspicious person was seen. But I'll move on to harmlessness, because our position is ultimately, even if this is hearsay, and we do agree that the imputed knowledge doctrine or collective knowledge doctrine is something that's in the Fourth Amendment context, not a hearsay context. The judge can be right for the wrong reason, but that, we acknowledge that that's not really in the context of hearsay. But we would argue that it's harmless because there was that same officer's testimony who said he did not see any suspicious activity or individuals in the area. And we also have 2 Axon videos from 2 different officers showing them trying to get into this building, driving around, walking around, and there's no one seen in the area, or no other person. So we would argue that the videos that the jury's watched, as well as the testimony from that officer, supports that a harmless error if any error is found, it can be found harmless in this case. I don't have any further presentation. I think I would just rest on my brief for the rest of the issues. And yeah, if this court wants to hear about Reynolds for the first issue, we'd be happy to do a supplemental brief.
I wonder, before you close, if you could address my question to your opposing counsel, and that is, in the context of a cumulative error analysis, even putting aside the instructional questions, if we're dealt with, say, a hearsay error, and perhaps some of these comments in closing argument that were troubling, how do we analyze those?
I think that it is true that for harmlessness and prosecutorial error, the state does have the burden, and it is under Chapman and that constitutional error. So, I mean, to look at it from that standpoint, we are bound to that, to the state having to prove that those errors aren't harmless. But mixing that with the hearsay and the statutory harmlessness, I don't know. I mean, I guess if we've proved it under the greater burden, we've proved it. So I don't really know that I have a good answer to that, other than we do recognize that and do believe that we can meet our burden for harmlessness in the prosecutorial error standard. So I don't know that I have a better answer than that, Your Honor. I didn't really think about the mixing of those two standards before today.
All right, thank
So-
you. Are there other questions from the panel? All right, thank you. Thank you. Counsel, you have 3 minutes.
Your Honor, I just wanted to make 2 quick responses. One, I think this first time we're hearing that maybe it's not hearsay, and so procedurally, I think that was defaulted by failure to brief. But also, and Your Honor already pointed this out. The content, I mean, the implication of this is there was traffic, and that the substance of that traffic, we're testifying about what the substance of that was or was not in this case. So that is a statement and content. So we think it is hearsay, and should be avoided. On the second point, on second issue, Your Honor, and Judge Warner, you point out, like, well, why even have this instruction if, you know, general credibility instruction enough? And the state's response is, well, there were other things. There's a reasonable doubt instruction, and this guy had an attorney. Well, that's true in every case. And so I don't think that's an answer to your question, Your Honor. I mean, the end result, if the state's right about their analysis here, is why would we even have this instruction? Thank you.
Okay. Thank you very much for your arguments, both your written arguments and your arguments today. The court will take the matter under advisement and